Hey everybody, hey, we're here today to talk about Judge Duffin, Magistrate Duffin's decision on the state's motion to supplement the record. So anyways, here it is. The respondent appealed the court's decision on September 9th of 2016. On October 5th of 2016, the respondent filed a motion to supplement the record on appeal. The respondent requested the court expedite the resolution of the motion so that it would affect its appellate brief, which is due on the 19th, which is tomorrow, by the way. The court ordered Dassey to respond by the 12th, which he responded by the 10th in plenty of time. The respondent is essentially seeking to add 5 new exhibits to the appeal, and now we will go into what those 5 exhibits are. And here we have basically the list of things. Now, the first 4 are basically already in the record in some form, either in transcript or video or audio recording. But the trick here is number 5, which is coming up here. That is Kayla's written statement that was collected on March 8th of 2006, 7 days after Brendan was arrested. That is what is the problem. Brendan and his team don't want it admitted. The other 4 things Brendan and his team have no objection to. So that's what's interesting. Now we have the document stating that, basically none of these exhibits were before this court when it considered Dassey's petition. But exhibits 1 through 4 are not opposed by Dassey, but they do oppose 5. Then it goes on to say, if anything material to either party is omitted or misstated in the record by error or accident, the omission or misstatement may be corrected in a supplement record, which may be certified and forwarded to the court. So here we have them, where he goes on, this provision is not an invitation for parties to add to the appellate record matters that were not presented to the district court. And then he cites case law here. It does not give this court authority to admit on appeal any document which was not made a part of the record to the district court. The purpose of the Rule 10e is to ensure that the record on appeal accurately reflects the proceedings in the district court, thereby allowing the Court of Appeals to review the decision of the district court made in light of the information that the court actually had before it, which makes sense, because if you start changing the information when you start going on appeal, you're not appealing the original case anymore. You're kind of appealing something different. So anyways, that makes a lot of sense to me. So it's not to enable the losing party to add new material to the record in order to collaterally to attack the court's decision. So it's also not such a great thing to just go ahead and willy-nilly add things to the record and supplement it. Although the courts occasionally have relied upon the stipulation of parties under the Rule 10e to expand the record beyond matters presented to the district court, citing case law, the court treating the respondent's lack of objection to the petitioner's motion to expand the record on appeal standing alone, basically all by itself, is not a good enough reason to go ahead and allow this supplementing of the record. It's just not enough, really. So it taints what actually happened in the district court, as he was saying. So this is where, in my opinion, it really starts to get good. Duffin goes on to say, the respondent has made no effort to show that the relevant exhibits were omitted due to error or accident, as required under Rule 10e. The decision to initially omit the subject exhibits from the record may have been a conscious strategic choice on the part of the respondent. Unlike a pro-SE prisoner or petitioner who might be reasonably mistaken as to whether or not a relevant portion of the state court record is automatically forwarded to the federal court, the respondent was represented by competent and experienced counsel despite the lack of objection from Dassey. Rule 10e does not permit the expansion of the record to include matters that the district court did not have the opportunity to consider. Okay, and then we go on to say, moreover, some of these exhibits are cumulative. Exhibits 2 and 4 are simply audio recordings of interviews that, the court already has transcripts of on the record. Exhibit 1 is a transcript of an interview at the Two Rivers Police Department, and Exhibit 3 is the video recording of the same interview. The police department interview was conducted at the urging of the district attorney due to the poor audio quality of the recording of the earlier February 27th, 2006 interview. and was intended to be a redo interview of what was already on the record. Now, what I find is funny here is that he's saying all this stuff is basically already in the record, and they're offering to put in the record something that has very poor audio quality as it is when the transcripts of that are already on the record. I think that's hilarious. But anyway, moving on to Exhibit 5. The respondent argues that it is relevant to show Dassey's confession was reliable. Basically talking about Kayla's written statement on March 7th. Anyways, however, the court concluded that the reliability of Dassey's confession is irrelevant. Okay. Even if the Court of Appeals were to disagree with this court's conclusion, the statement was written on March 7th of 2006, after Dassey's March 1st confession. In the interim, Dassey was criminally charged, and the details of his confession were widely publicized. Moreover, Kayla Avery disavowed the statement at trial, testifying, I kind of made it up the statement, and I'm sorry. I also happen to think that Magistrate Duffin makes a very excellent point here, because it's on the 7th. It's 6 days after Brendan was arrested. His confession has been put all over the press by Ken Kratz and Sheriff Poggle, and we already see how the way they were treating Brendan and the way they were questioning people in this case, trying to manipulate statements. If you read enough of the CASO files, you'll see that. So, I mean, it's a very valid statement that he's making here, that statement was made after a lot of coloring had happened. So, as generally cumulative, and thus in the court's view, largely irrelevant, it might seem a little matter to add the exhibits to the record, especially when those exhibits to which Dassey does not object. The problem is that reliance upon the court's inherent authority must be reserved for extraordinary circumstances. In extraordinary situations, the circuit court may consider material not presented to the district court when it believes that the interests of justice are at stake. The respondent has failed to demonstrate that this is an extraordinary case. Therefore, the court declines to exercise its inherent authority to expand the record and include documents that this court did not have the opportunity to consider when deciding Dassey's position for the writ of habeas corpus. It is therefore ordered that the respondent's motion for the supplement of the record, or to supplement the record on appeal, is denied. Dated at Milwaukee, Wisconsin. This is the 12th day of October 2016. William E. Duffin. So, to sum up, I think it's kind of a funny thing if you think about it, that in that first paragraph, he basically sums up that on September 9th, the respondent or the state filed their appeal of his decision to throw out Brendan Dassey's confession and overturn his conviction. But right now, so they filed their appeal, appealing his decision to throw out Brendan Dassey's confession. So they're now basically, they went almost a whole month until they waited until October 2nd, which on October 9th would have been a month, and knowing that that they were all due in court on the 19th to file their appellate briefs, basically. They show up they basically file on October 2nd that they want to supplement the record. Basically with, 16, 17 days until the crucial day, when they already had almost a month already to decide whether they would want to do this, they suddenly do it then and jam everything up the way they did. It forced Brendan to have to respond to it, which he had until the 12th to respond to it. And, it's just, I know the courts don't like their time wasted. And you get the feeling from Judge Duffin here that he feels like that the court's time was being wasted with this. And I don't know if you notice it, but it's almost like he's poking fun at them at certain points. But at least, you know, at least finally the thing that's great about it is that finally there's somebody there who is calling BS, who isn't just, you know, co-signing on, you know, this BS that is this entire Avery and Dassey case. It's good to see him, you know, not allowing them to just start adding more evidence. He's basically making them be honest, and I dig that. So anyway, that's my video. I got a couple more coming soon. Those of you who have been wondering where I was and if I was going to be making any more videos, I apologize. I've been building a computer. I've got it almost all together. I just got to, you know, get the software together for it and stuff, but it's almost ready. So that's going to be the new computer for making videos. And so once that comes together, I've already got a few ready. So for any of you that were worried about that, you don't need to. There'll be a few more videos coming out very soon. So we'll see you guys later.